Sarah Vickery. Today I'm reporting on school law regarding collective bargaining. So what is collective bargaining? Well, the book defines collective bargaining as the process that entails bilateral decision-making in which the teacher's representative and the school board attempt to reach mutual agreement on matters affecting teacher employment. Now, in other words, that means that we as a group elect representatives to represent us in negotiations with the school board over things that are part of our employment, so our entire union contract. In my district, this group is referred to as the executive board and is made up of members of the union and representatives from each school. We meet monthly to discuss contractual concerns, and in negotiation years, we meet with an ITF representative to discuss negotiations of the new and old terms of our contract. What are our union options? There are two options. Now, your school makes this decision for you. You don't get to pick your independent union. However, you can join a separate union and be part of two at the same time. So there are two union options that are the major unions. There is the American Federation of Teachers, which has the branch of the Illinois Federation of Teachers. And then there's the National Education Association, which their local branch is the Illinois Education Association. So, where did it all come from? Where did this idea come from? Well, the idea comes from the First Amendment of the U.S. Constitution. It states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and abridging the freedom of speech or of the press, or the right of the people to peacefully assemble, and to petition the government for redress of grievances. So because this talks about the right to assemble and the right to grieve, a lot of people interpret this to mean that they are supporting unions. Now, that is not what this amendment is actually meant for, but it is the basis for where the idea of unions came from. Now, while the Constitution does not protect the right to unionize, there are several federal laws that do represent this situation. So first we have the National Labor Relations Act of 1935. Now, this allowed private sector employees to form unions and take part in collective bargaining to correct the imbalance of power between employers and employees. Basically, they found that as one single employee, if I go to my boss, I don't really have a whole lot of power over them. They're my boss. So I can't really negotiate very effectively. So they found there's more power in numbers, obviously, and using that power in numbers tends to make the employers be more fair to their employees. Now, there was an extension of that act called the Taft-Hartley Act of 1947. After a major strike, they actually created a ban from labor union striking because it shut down too much and it was just too hard for everybody. So they made a federal law banning those labor unions from striking. Now, on to Illinois law. The Illinois laws are what specifically governs us. Since there's not a lot of federal laws, most of the decisions made are varying from state to state, and they are drastically different from state to state. So, the first Illinois law that we're going to talk about is Senate Bill 1474, or the Collective Bargaining Freedom Act. Now, this was only done recently. Governor Pritzker actually put this bill into action. So it states that those covered by the National Labor Relations Act may execute and apply agreements requiring membership in a labor organization as a condition of employment. So basically, if you want to work at a school, they can make you become a member of the union, or at least pay to be a member of the union. States that employers, employees, and their labor organizations are free to bargain collectively. So we can create a union and we are allowed to work together to get more rights in our contract. And then it provides the authority to enact laws or rules that restrict the use of union security agreements between an employer and the labor organizations vested exclusively with the General Assembly. So that creates no right-to-work zones. In Chicago, this is a major issue. They were trying to create right-to-work zones, and that actually went against the Illinois law here, and it had been a big issue, and they wanted to make sure that we could still have our union rights. Now, this is the next law that we're going to talk about is the Illinois Educational Labor Relations Act. Now, there was an Illinois Labor Relations Act initially, but they realized that didn't apply specifically to education workers, and they wanted to make it more specific to us and our needs. So, they created a second act afterwards, the Illinois Educational Labor Relations Act, and this grants educational employees the right to organize and freely choose their representatives. So, it's not just about our right to unionize, but also that we can pick who we want to represent us. They cannot select for us. It can be somebody that we think is impartial. Then it requires educational employers to negotiate and bargain with employees' representatives and to enter into written agreement with their representatives. So they have to provide us a contract based on this law. They cannot just make an agreement and then go back on it if they'd like to. They have to commit to the written agreement. And then establishing procedure which protect the rights of educational employees, their employers, and the public. So it actually creates a whole very, very long set of steps to every process of how you negotiate. They wanted to make sure that it's very clear cut and there's no questions about it. There's no way to loophole around things. So it's a very long document that details every single portion of what can be negotiated, what can't be negotiated, and the terms of those negotiations. Now, the Illinois Educational Labor Relations Act actually created the Illinois Educational Labor Relations Board. Now, this is a board made up of 5 members. Every governor is allowed to appoint their own new members to it, so the governor appoints them, but they have to be confirmed by the Senate. So it cannot just be him picking whoever he'd like. It has to be somebody who they approve. Now, they have to have certain stipulations. They have to be an Illinois resident, obviously, to be part of the Illinois Labor Relations Board. And members must have a minimum of 5 years of direct experience in labor and employment relations. So it cannot be a rookie. It has to be somebody who actually knows what they're doing as part of this. They also make rules and regulations to carry out the purposes and policies of the Illinois Educational Labor Relations Act. So sometimes, even though it's a very long document that's very, very well set up, there are some questions of situations that could be loopholes based on the fact that it came out a while ago. So they actually go through and they create the rules and the regulations that address what was not addressed previously in the Act. And they can investigate charges, issue complaints, and certify the results of representation in elections. So when we vote for our representation for who we wanted to represent us in our negotiations, sometimes people don't think it's very legitimate or they're concerned about what went on. So they actually investigate this and make sure that everything was done above board and done to the stipulations of the Act. The role of collective bargaining in schools. So collective bargaining determines your contract. It goes through and it talks about, the hours you work, how much you get paid to work, those salary schedules that you're taking part in. All of those things are determined by collective bargaining. Now, there are a number of things that cannot be addressed by collective bargaining, but specifically, everything that's in your contract is part of collective bargaining. That's the things that your team, your executive board, or your negotiation team has gotten for you. And there's usually give and take on both sides. So things that you lose in your contract negotiations usually get you some new benefit in it. Now, your principal's role. There's not a lot outlining what exactly a principal is supposed to do as part of collective bargaining. A lot of it starts off at the administration side as the superintendent. Now, the superintendent determines who they want to have present on their side. Now, this is usually a small group, no more than about 5. And this small group can be made up of whoever this superintendent trusts. Now, in smaller districts, that might include principals. In bigger districts, that does not always include principals, such as my district. We have a lot of schools and we have a lot of administrators, and our superintendent does not actually include principals in the negotiation portion of collective bargaining. She picks administrators that are from the district office. So, if it's in a smaller district, you may be included in this, and you might have to negotiate on the side of the administrators. If you are in a bigger district, you likely will never have to take part in it. Advice for following the contract. I've talked to a lot of principals about this, and every single one of them told me you need to know your teacher's contracts. You need to know them inside and out. It is not a joke, because you can lose your job over a grievance. So you want to make sure that you know their rights and you are not asking anything beyond their rights. You want to know exactly what is considered an extra position, a supplemental contract, what are their hours, what additional things can you expect from them, can you ask them to send you their lesson plans, or do you have to just look at them because you are not allowed to actually take part in keeping a copy of them? You need to know that inside and out, because if you break that contract, then your job can be at risk. When in doubt, ask a union rep. We recommend going back to your contract whenever possible and looking back at it again and again. But if you are in doubt about the wording of it, sometimes the wording of a contract isn't exactly super clear cut. Then if you're questioning the wording of it, go ask the union rep for the teachers. Make sure that you are always erring on the side of the teachers until you are certain, because otherwise this can be your job. Now, grievances. Grievances are a formal complaint by a worker against an employer for any type of dissatisfaction in the workplace. That can include working conditions, unfair treatment, or violation of the contract. Now, most of those situations will come into violation of the contract, but there are some stipulations that aren't part of the violation of the contract portion, so they might be asking you to do an additional duty that's not specified on your contract act, or they might do something like they're not going to fix your air conditioning. That would be considered working conditions that aren't necessarily detailed in your contract, or unfair treatment if you feel like your administrator is being biased against you, then that wouldn't necessarily be detailed in your contract, but it would be considered something you could grieve them for. Now, there are a lot of steps to grievances, and it varies from district to district, so you want to make sure that you are looking at your contract again, and looking at what those steps are. So in my district, our grievances are set up in a 5-step process. So if you have an issue, any one of these situations has applied to you, then you have to start off with an informal conference against the administrator or the employer that did this to you. So if it was your principal, you have to informally sit down with them and try and come to a agreement on how to move forward. Now, additionally, if that's the case, and it doesn't work out and you don't come to any sort of conclusion that you're satisfied with, then you would go to your union rep and you talk to them about it, and they would come and they'd represent you for an administrative level formal meeting where you will discuss the concern, the complaint, and figure out if you can get it settled like that with a intermediary. Now, within 15 days of that, if you are still not satisfied with what went on, you can file for a superintendent meeting. Now, it's another formal meeting, and talk to your superintendent about this grievance that you have, and see if you can get it settled with the superintendent and the principal and your union rep there. Now, sometimes you're still not going to be satisfied by that. Maybe you haven't gotten the results you want or that you think is fair. Well, within 7 days in my district, you have to file to see the level of the school board. So you can go before the school board and talk about your grievance and your concerns. And at that level, obviously there's more people to have a little bit more opinion on it. And if you're still not satisfied by that point, you have 10 days after that to file for arbitration. So they can get an impartial arbitrator brought in order to look at your grievance, somebody who's not from the district, who's completely impartial, to look at this and determine what they consider the fair answer and get it solved. So those are your 5 levels of grievance. Now, there are a number of subjects of collective bargaining. They have different terms for them. The first starting one is mandatory subjects of collective bargaining. Those are proposed subjects determined to be mandatory and must be negotiated. Those are anything that deals with wages, hours, or terms and conditions of employment. Now, those every single year, or every single contract year, must be discussed. They are not optional. You have to talk about how wages, make sure that you're updating things as you're supposed to. Hours, make sure that they're being updated in terms and conditions. There's also permissive subjects. Now, those are items that can be negotiated if both parties agree. So if our school district thinks that we need to change something, if the school board thinks we need to change something, administrators think we need to change something, then this can be brought up here, but it has to be something that we agree to talk about and they agree to talk about. Prohibited subjects of collective bargaining. These are items that cannot be bargained because the power is already reserved for the school board for that particular item. Now, there are also a number of legal things that cannot be negotiated just because they are part of a state law, not based on our individual negotiations. So if your school board reserves a power, then that stays out of it. But also Article 1 of the Illinois Pension Code, which is the general provisions for pensions. And then Article 14, 15, and 16, which all talk about state employees' retirement, teachers' retirement, and the state university's retirement system. So basically things that are based on Illinois' governance of the retirement system, we don't get to negotiate. That's the state. Alright, so here's your scenario. You are an administrator in the COVID-19 pandemic, and your teacher's contract is up for negotiations. What new mandatory subjects would you like added to the negotiation table? Now, this is a very real possibility that, this might, for some of us who are trying to get in right away, we might be administrators dealing with the COVID pandemic. Now, obviously, we've had a lot of changes that are not something that we could have predicted in schools. So what changes would you like to see brought into the contracts so that you are covered for what you need for the pandemic?